Yes, welcome to the No State Project for January 20th, 2016. Glad to be with you here from the fortified compound in California, San Bernardino. And it's January 20th, 2018, and the website, of course, is markstevens.net. I do appreciate everyone tuning in today for the big broadcast here on the Liberty Radio Network, LRN.FM. You're going to notice that we have all new bumpers. And the big reason for that is because when I went to stream the show live on YouTube, I got hit with a copyright claim. So when I posted the video, not everybody was able to actually hear it. And so since that's where the overwhelming majority of the audience just happens to be, I had to change the bumpers. But it's Double Bucci. It's a good friend of mine, Chris Case. Fantastic blues player. Well, actually, maybe getting some more of the footage of that concert that night that was in Key West. So I'm hoping Chris is going to be able to call me real soon, and he will have found those tapes that he can then get onto a CD and make available, because it's a fantastic CD. Man, did they kill that night. But we got a lot of stuff to get to. You want to join me on the big show? Of course, it's 218-632-9399, 218-632-9399, and it's got the, what do you call that, the hashtag, 2020 with the hashtag. You can also Skype me at Frank Rizzo 3, Frank Rizzo with the number 3, and we can also get you then into the No State Project Sky chat. And just briefly about the chat. The chat has a particular purpose to it, and that purpose is to help people learn to effectively defend themselves in court. If you're in the chat and you want to discuss something else, generally get it out of there. Just create another chat. No one is saying don't talk about this, or I'm not making any determinations of whether the subject matter is right or wrong. It's just not appropriate for the chat. We just don't discuss that kind of stuff. We don't discuss religion on the show. We don't have that discussion in the chat. We want to keep the damn chat productive, and that is doing the damn role play. Primarily helping people who are going through these court cases. So we've got, I'll talk about this in just a moment, Bo is actually sitting in jail in Texas. So hopefully we'll be able to get a habeas corpus out to him and be able to get him out of there. But the chat, yeah, it's for role-playing. And I just want to point something out to our friend Shelby, who seems to be really narrowly focused on his claims against me. I have said over 1,000 times, the closer you are getting the trial, the less chance you have of getting the ticket tossed out. It's the way it always is. That's why we do our best to get it tossed out with the motion to dismiss at the arraignment or at the pretrial. So don't discount the effectiveness and why we do the role playing. Just and say that it's not that effective because the majority of complaints that actually go to trial don't wind up with a good resolution. Because most of the times we get things tossed down, it is before that. But keep in mind that people are going to the arraignment and killing it at the arraignment. And then they're also going and having the prosecutor at the pretrial conference or the case management, depending on where you happen to be. And they do such a good job there by using the Socratic method, by using the tactics that they've learned here on the show, and by practicing it in the role play, that they're able to be very effective at the arraignment and at the pretrial so as to preclude an actual trial. Because again, chances are, if it is at trial, it's not going to go well. Which is, look, and here's a little bit of evidence of that, is we are almost at 100%. I know I am, and I know other people are. Unfortunately, we have one holdout in Canada, one out of thousands, where every single witness they've brought against us, government witnesses that are there to testify that we broke the law and that the laws apply to us, every single one of them has been declared incompetent by the judge. Every single one. I had one case where Brian Strong was the one that was the judge. They called 5 police officers. Even Brian Strong, who's still a practicing attorney here, back home in Mesa, that I impeached and showed how incredulous and incompetent all 5 witnesses are, and showed that not only that, but they all lied and changed their stories. Even that wasn't enough to change his mind. So we're dealing with crooks here. They're absolutely crooks. So knowing that we still, even having the police officer impeached, declared incompetent to give legal conclusions, even though that's what he did, and we can still not prevail. Let me explain something here. This is not a matter of me being just a pissed off anarchist. This is not a matter of me being biased against them because they're criminals. Okay? This is a matter of looking at the facts, looking at the context, and making a logical conclusion from that. If the police officer is testifying that the laws applied and you violated them, and when you ask him questions based on the evidence that those claims, those legal conclusions are based on, and the judge doesn't allow him to testify because he's not competent to make legal determinations, so he's not competent to say you broke the law. If you still lose, that is not a statement about my bias. That is a statement about how dishonest the system and the people that comprise it really are. So keep that in mind. It's not a matter of that the Socratic method is not effective, because what we'll show is, like with Bao. I'm sorry, I mispronounced that. He was on the show. I thought it was Bo. It's Bao. We'll show that by using the Socratic method, even if you don't get the ticket thrown out, the fact is we're showing clear and convincing evidence of just how dishonest these people really are. So this crap, it doesn't work in New Hampshire, it doesn't work up here. No, that's not true. When you have a judge like Mr. Burke state that jurisdiction is a trial issue and lie like that, you're showing how you've gotten testimony, you've got direct evidence of how dishonest it is. And to be able to have him do that within a minute or two, lying for the prosecution, and on video, that seems to me it's pretty damn effective. So let's not discount the fact that we have so many nolo prosequis where the prosecution withdrew. Why are they withdrawing? Primarily because people have gone in who have done role-playing, whether on the No Stay Project Skype chat or they've done it on their own, and they've gone in and they have effectively confronted the prosecution on their BS. That they're claiming, they're making legal claims, and they don't have any evidence, and they don't have any damn witnesses. So I'll be the first one to admit, again, for probably the 5,000th time, the closer you get to a trial, the slimmer the chance that then the chances are that you are going to have a peaceful, a positive resolution to your complaint. We're doing everything we can to avoid that, and that's why I've said so many times about this. I'm repeating myself again. If you cannot get it tossed out, before the trial, then our only hope is to cross-examine the witness. And if they still, after cross-examining the witness and showing that the witness is incompetent to testify, if they still don't, you got evidence of a rigged game, and it's usually a slam dunk on appeal if they actually address the issue. We'll continue with this and your calls. An update about Bao rather, here, but the number to join me is 218-632-9399, 218-632-9399. The passcode is 2020. Yes, welcome back to the No Stay Project, live from the fortified compound in San Bernardino, California. Glad to be with you here today, everybody. And we were talking about the chat before. I think it's a fairly simple thing. You know, if you have a purpose to the chat, just keep it to that. So just, you know, invite somebody into another chat, and you could talk about whatever you want. I don't give a damn. But the purpose of the chat, why I started it and need to moderate it better, is to help people in court. And that's the primary purpose. And so let's keep it to that. Let's keep it focused. It's just, to me, it's just so easy to start another chat. If anyone's interested in chatting with you, just start another damn chat. I mean, it's really not that big a deal. So, but if you are prepping for court, keep in mind that, yes, the overwhelming majority of tickets that we have tossed out are tossed out prior to trial. But we have had people, of course, Jermaine, and people who have been on the chat and have called into the broadcast. Do I remember everybody's name? No, I'm sorry. I work with a lot of people. But if you go through the broadcast, there's a lot of people that have called the show who talked about what happened, had a ticket thrown out, and yes, they've gone through the role play. Did every single one of them go to trial? No, of course not. Do we then... So, maybe it's supposed to be that since the majority of tickets that are thrown out without a trial, does that mean we shouldn't prep for court? Does that mean we shouldn't have to learn to effectively defend ourselves? Does it mean we're not supposed to learn how to apply the principles of logic to show that somebody's argument or claim is ridiculous? I mean, come on. No. No. Again, I've said it 5,000 or more times. The closer you're getting to trial, the less chance you have of a successful outcome. They have given you a clear history up to that point, everybody. Logic and reason and fairness are not a part of the equation with these people. And again, if you go in and like we've done almost 100% of the time, when they declare the cop incompetent to actually say you broke the law and they allow him to testify anyway, you're in a rigged game. Is that because, well, Mark Stevens is an idiot and his anarchist stuff doesn't work, especially if it's New Hampshire? No, it just means you're dealing with a criminal. You're dealing with a crook. And the proof of that is that they force perfect strangers to pay them. And they have a prison system. So there's the damn evidence of that. But Bao, who has called the show, is sitting in jail as we speak. It is the Lon Evans Correction Center and in Fort Worth, Texas. And I did get some information here regarding the judge who did this. He is being held without bond, or it's unsure if it has been revoked. But the judge, we actually have a picture of Judge Cheril S. And she has ordered a mental, from what I see, a mental or a competency, and they have forced an attorney on him. So whether or not that attorney is working with him, because from what I heard, what I've read is that he is not working with the attorney, but that doesn't mean that he's actually able to defend himself. It's unclear as to whether this competency hearing is really a psychological evaluation. So that's something we have to keep in mind also. Not to scare people into not defending themselves, but a handful of times in several thousand times that we've done this over the years, yes, judges have threatened and some have carried out the threat of a psychological exam. Now, we know Kerry, who calls into the show all the time, was at a competency hearing yesterday, and I have not heard back yet, so I don't know the details of that. For Bao, what we're trying to do is, I'm going to do the best that I can. I am out of town. I am in California. I will be back tomorrow night. I will do my best to get a habeas corpus in. I'm waiting. Somebody is sending me the cliff notes as what happened, so I don't have to spend as much time going through a transcript. But it's pretty safe bet that the prosecution had no evidence of jurisdiction, period. Whether it be territorial, personal, or subject matter jurisdiction. The easiest one, of course, to show is personal. And that this Judge Hardy is not presuming innocence, that she is taking the claims of the prosecution as absolutely true, even though there's no evidence to support it. So that, to me, I believe is sufficient to show that the detention is not warranted, it's unfair, and it's not legal because there isn't any evidence to actually support it, that the prosecution is arguing without evidence, which of course is prosecutorial misconduct. So we do have somebody who, I'm not going to give the name out, who contacted me yesterday, but I wasn't able to get the call because I was out of town. I was traveling. I got stuck doing my midnight run from Mesa to San Bernardino. At least there's not as much traffic. But I'll be working on a habeas corpus petition, and so this individual who knows Bao may be able to either get it to him, or he's probably more than likely going to have to file it himself for Bao, because if they have forced a public defender on Bao, they may use that as grounds to refuse to hear the habeas corpus if it's signed by Bao, because he's represented by counsel. Even though it's a completely different proceeding than the one that this Judge Cheril Hardy is incarcerated him for, and it shouldn't make a difference. The attorney is not representing him for that. It still may be better to avoid that problem. It is Texas, so that's what we'll do. So I'm hoping to get that. I doubt I can do it today, but I'll probably get it out first thing Monday morning. They get filed on Monday afternoon, and see what we can get there. Adam Kokesh is also in jail. I believe he's been arrested on 2 felony charges and a marijuana charge also in Texas. So where is it here? I guess it's Wise County, Texas. There's a lot about, I guess it was a lot about it on Facebook. He was pulled over a number of times and finally arrested, and he's being held on a $76,000 bond. So, and I think he's refusing to bond out anyway. Typically Adam works with an attorney, so I doubt that there's anything I can do. If somebody wanted to participate with a habeas corpus, again, I don't know if he would do it for himself. I don't know. Or maybe somebody's willing to do it for him, because a habeas corpus can be done by anybody on behalf of somebody who is incarcerated. So now whether they're going to uphold that, we'll see. We'll see. But they're both in Texas, so that kind of cuts down on the work that I have to do. So, excuse me. So I should be able to get both of them done on Monday. So if there is anybody in the area, Wise County, Texas, I don't even know what, then contact me at markstevens@mail.com if you're interested in helping Adam by doing a habeas corpus. I would suggest doing it in your own name and not trying to get it to Adam, because you probably can't get it to him at this point. We'll be back here on the No State Project in just a moment. We'll get to your calls. Again, it's 218-632-9399, 218-632-9399, 2020, and the # is the passcode. We'll be back in a moment. Yes, welcome back to the No State Project. It's my buddy Chris Case down in Key West. So if you're down in the area, he's still a regular celebrity there playing his blues like that. So definitely check that out if you're lucky enough to be in the area. That's what we got to do. We still got to set up a workshop or something down there in Key West so that I can actually jam with the boy. But good stuff. What I need to do is get his CD uploaded onto YouTube so that more people can hear that. And he was just doing the Freddie King song, Same Old Blues. And boy, let me tell you, that, yeah, good stuff. I'm not going to give out the number for a bit because we're already loaded up. But I want to bring Joe up. Joe has got an update on Bao because I believe he spoke with him already. So welcome back to the show, Joe. So you've spoken with Bao?
Well, I'm sorry. I meant to relay that I've spoken to him probably more than anyone else. I've done a lot of one-on-one preps for court with him. I did listen to the 2 phone calls that he made from jail to members of the Skype group and heard his account. What else can I clarify for you?
Well, just let us know what's going on now. Now, we get that you've got some personal knowledge there, so just let us know, pretty much what's going on.
Right. So basically what this is a standard scare tactic. We've seen it before, first with a guy named Scar a couple years ago, and Gabe. I believe there was one other who got psych evaled.
Did they do that to Robbie?
Ambush.
Did they do that to Robbie?
Yes, they did as well. You're correct. They forced him on him too. So this seemed like an ambush. Bao was, he's coming along nicely with his, practice and role plays and whatnot. He did not, quote unquote, mess up and kind of like not see the contempt threat coming and just missed it and got clumsy. He didn't do that. And while speaking from jail, I mean, I've never heard a guy sound more upbeat. So he's not in there kind of going, what the heck, with any kind of panic. I mean, he knows, trust me, I made it more than clear what the risks were. He was heads up. And when this happens to somebody, what I try to keep in mind is, there's such a silver lining to this cloud. Like whenever somebody comes out, this is the first time he's ever had to deal with something like this, being in a cage like this for this reason. The experience adds something to what they bring to the table in the future. And it's always exciting for me to discover what that new thing is. These types of, it's my humble belief, right or wrong, that these types of actions taken by these criminals, legalized criminals we call judges, are ultimately self-defeating, that they ultimately only strengthen their true and only effective opposition, us, anarchists, and that it's just a matter of time before they figure that out. One last thing I want to conclude before I give you the mic, Mark, is I just want to bounce an idea off of you, and maybe you've already been doing this. In short, obviously if we take what we do in court to the fullest extent that we can, it can easily last up to a year. Have you ever thought of, along with your brilliant documents, your motions that we all file, have you ever thought of combining those with a short-term game that is specifically designed to resolve the entire issue within one hearing, the first arraignment attempt? We get to say a few sentences as to the true observable reality that's actually going on based on, of course, logic, ethics, and factual evidence. Then basically say, what do I need to say? What lie do you need me to tell? How much do I need to pay for this to all go away and me to be free of your coercive threats? And I wonder if people saw that, and if judges heard that across the country and growing. I mean, it could even be close to a script if it was short enough. I wonder how it would affect them if they saw a unified movement from an anarchistic cause challenging the crucial missing element of jurisdiction. What do you say?
Well, I think we kind of do that with the unsigned plea of guilty. Hey, I'm willing to plead guilty like now if the prosecution has met that burden. I mean, wouldn't that, you would think anyway that would make quite an impact.
That's true. Of course, that's true. But as you know, the judges can kind of ignore that unless we were to say, hey, here's my unsigned plea of guilty, and I'm gonna sign it and pay the fine and be done with all this today, no matter what. I just make a few challenges to their missing factual evidence, and then actually go ahead and sign and pay the money. Maybe, as you well know, most people can't go to court. They got to go to jobs. That's why they schedule court during business hours. And so I'm just wondering about offering a one-day strategy for people in those situations. I don't know. This isn't fleshed out, so by all means, feel free to criticize. I'm just tossing it out there.
I think the only other thing that I would add in there as a way to kind of raise the stakes, at least for them, would be, I'm willing to plead guilty right now if the prosecution has met their prima facie burden. However, if that is not allowed and you cover for the prosecution's lack of evidence, then I want, then see here, this is a draft of a claim I'm filing against your insurance today.
I like that. maybe I can best summarize this way too. As you well know, playing out the long game and taking this to the extent that we're able to will always be done differently by different individuals. And I see them taking advantage of this. I see them, as judges always do, probe for weaknesses and then exploit them as much as they can. And because, as you well know probably better than I, that it's really impossible to train layman members of the public to be really good at this effectively, within months or what. I just wonder if the judge is seeing the solidarity of scripted language. I just wonder how they would respond to that, or because I'm just looking at it as what's effective. I know what Bao's doing is effective because it causes. I basically judge effectiveness by how much fear it causes in the actions they display. I'm just want to bounce this off you for your input. Maybe I'm wrong.
I think it's accurate to say that the reason why these handful of people, thank goodness, have been dealt with the way they've been dealt with is because they are not wanting these challenges to be done. Because and you've heard, you're familiar enough, that the only, what's the word I'm looking for? The only counter argument that they have is to just make the claim that the prosecution isn't required to prove the foundation of their complaint. It's because when it comes down to it, all we're doing is challenging the prosecutor or the police officer or the tax agent's legal conclusion. That's all. That's what it comes down to.
Sure.
And for them, so you have to take that context and weigh that against to the extreme responses that we sometimes get. And could it be fear? Could it be humiliation? Something is driving them to keep us, and make an example of somebody like Bao to not go into court and do that. Is it because, so could it be fear? It may actually be accurate. Yeah. Hold on just a second. We're up against the break. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, and I think it's a good idea to go in with a unsigned plea of guilty, of course, and let the judge know that if you're not going to hold the prosecution to their burden, I'm going to be filing my initial claim today against the city or the county's insurance for the damage that you're going to cause me. You seem very intent on causing me, but we'll be back with Joe in just a moment. Don't go away. Yes, welcome back to the No State Project. I'm going to bring Joe back up in just a moment here. And I got the cliff notes regarding what happened with Judge Hardy and Bao. So what they're saying here, Judge said Bao asked for if jurisdiction was an element. Judge said she appointed a lawyer for him. Bao objected. Contempt was never an issue. Let's see, the lawyer had tried to talk to him. He said no thanks. Back in the court, the public defender whispered something to the judge. Judge said she's going to enter a psych eval. So it's definitely a psychological evaluation. At that, he was detained and everything was taken from him. No psych evaluation yet. A second arraignment with a video judge. The magistrate pushed him pretty hard to say he understands, but he never said yes. She said everyone's rights to them as a whole. No charges were read. He was never informed of what the max penalty is or whatever he did. Right after that, there was another person in the room, tells him to sign. Bao didn't sign or agree to anything. Telling me I'm being held without a bond amount. Jail is mental bullying. If anything, one of the things he was trying to... Okay. The judge told him is now the bond's been lifted, whatever that means, and you need to see if you can get it unlifted. Wow. Well, welcome back, Joe. So were you aware of these details?
Yeah, most of them. The one detail that you mentioned that I want to make sure we don't gloss over was this lawyer, this public defender that the judge forced onto his quote-unquote side or whatever, was never helpful, was only speaking for the state. And when he went back into the courtroom with Bao, first he was whispering to the judge Now, that may not be... oh, I'm having a brain fart here. I'm sick, too. What is it called when the prosecutor and the judge talk in the hallway without anyone else? Gosh, I can't believe I'm so embarrassed. What's that? I'm sorry.
Ex parte.
Yes, thank you. Ex parte. It may not have been the prosecutor, so it might not be ex parte that way, but of course, I'll never agree to have this person represent him. It was against his will. He made that clear. And because it was a public defender, he was both licensed by and paid by the accuser. So I can't wait to see the motions that are going to go in to address these issues. But I thought that was one of many appealable errors and something I just didn't want to skip past.
Well, sure, I appreciate that. And someone's telling me here that they have him on a suicide watch. Now...
Oh, I totally would bet money, sorry to interrupt, that is only so that they can keep him in solitary confinement. They do not want what he's bringing into the jail for their other inmates to hear. This courthouse is aware of the video that I posted specifically about them. They are fully aware of what I'm bringing to the table on YouTube. And what, I can put their full names on a video, and now it's searchable forever.
Yeah, I got to do that
with
with
a solitary confinement justification.
Yeah,
go ahead.
I got to do that. I'm sorry for interrupting. That Judge David Gates. Now, when you search for David Gates, even though there's only that one picture available, you will get my videos.
Perfect.
Which on the front page.
I know they hate that.
Yeah, and Stephen Myrie. I've got a video I'm putting together, and I was able to confirm based on his professional history, because it included where he went to school. I actually have a very good picture of him. It's unfortunately 40 years old, but it's still a picture of him. So we're going to have a nice HD picture of that scumbag who, whether you agree with the Bundys or not, is completely irrelevant. This man was engaged in multiple cases of flagrant prosecutorial misconduct, and so when you type in his name, my video, and it already is there because I put his name in the title of the last video. When you type in Stephen Myrie, you will get my video now. So I definitely, yeah, so I can't, well, hopefully Monday or Tuesday I'll be able to put that together, but there's no information about this guy. But we have a picture of this judge that someone sent me, and so that's probably right. I mean, look, from what has been reported to me, and I do appreciate this, I'm not going to give the name out. I don't know if they want me to give the name out who gave me this information, but you've been able to verify this, that asking if jurisdiction is an element of the charge is somehow now sufficient factual grounds to warrant a psychological evaluation?
Yeah, and keep in mind, a lot of courtrooms, including the one I have here locally, until about a year ago, before the judge even came out for a typical traffic session, the court clerk would get everybody together. Hey, everybody, I got to say stuff. And as she would give a speech to prepare this crowd for traffic court, one of the things she specifically said was, you have this right, you have this right, you have this right. You have the right to be informed of all elements of the criminal charge. And then they stopped saying it altogether. So it's in their scripts. Even their system has in the past acknowledged this, and that's why it makes the point you just made even all the more valid. Total hypocrisy.
It really is disgraceful. And, of course, the hypocrisy that's through it, the double standards, it's one right after the other. And because, look, we know based on this behavior that if we were to say to the judge after they confirm that the prosecution can argue without evidence, so look, let me see if I understand. The prosecution can make legal claims against me with no evidence. And what would happen if I did that to you, or I made legal claims against the prosecution with no evidence? What would happen to me? You know damn well they would be threatening contempt.
Oh, yeah.
But the prosecutor can get away with it. So here, this is horrible. And anybody no one has come out and said, and hell, Bao was on the show. I mean, I think it was only the one time, maybe a month or so ago. But I have spoken with him for more than one segment. And based on that and what other people are reporting to me, there's nothing to indicate that the guy's suicidal.
Yeah, that's a total joke. Bao is one of the most happy-go-lucky people I know, and I am not just saying that because he's in Suicide Watch. I would bet $1,000 cash money that he's not worried even close to that. And if you listen to the recordings of him talking from jail, and I'm a guy who's talked to him for hours upon hours. He is not in any kind of downer, depressed mood. I've talked to more than one person calling from jail in my day. And after they immediately get out. And, man, Bao's in good shape. I wasn't even worried about that.
Well, it's definitely... I don't think there's any doubt that this is a scare tactic, and this is to get somebody to shut up. And, again, how many times have we got to say this? This is a matter of moral importance and ethics, honesty. If the prosecutor could support their claim, they would just put the evidence on the table. You could be wrong about a legal conclusion or a legal position, and the idea that they want you for a psych evaluation for questioning a lawyer's claim, or in this case, it's also a police officer's claim. Wow, that's some serious criminality there. But I think I've got enough information here to get a habeas, and I don't remember the name, but there is somebody who is in touch with me who is in the area. Who is going to be able to do the habeas. He's going to be able to file it for him.
Oh, good deal. Heck yeah, that's good to know.
Well, and we'll have to follow this. We'll be I don't know if I have any information for the Wednesday show, but hopefully, definitely for next Saturday's show, we'll have some information about what they're going to do with it. Keep in mind, this is Texas, and it's a habeas corpus, so they are going to do whatever they can to not hear it. And look, Joe, that's why I have those 3 monkeys on the back of Adventures in Legaland. You realize anybody who spent any time with these people realizes when it comes to the truth, they cover their eyes, they cover their ears, they cover their mouth. They don't want to see it, they don't want to hear it, they don't want to talk about it. And so they find reasons to not do anything with the habeas corpus. So I'll have to make a prediction. I think I already mentioned this. They're going to say he's represented by counsel and we can't do the habeas. That's probably what they're going to use. We know it's BS, but there's a good chance they're going to say that to avoid having to act on it.
Mm-hmm. And I also believe that a lot of the source of their motivation comes from, or maybe, I don't want to be certain, but I just find it highly likely that a lot of it comes from them calculating how the average random YouTube viewer will, what.
Well, we're up against the break, so just hold on, Joe. We'll be back. We'll be back here on the No State Project with Joe in just a few moments. So we're at the top of the hour break, second of 3 hours of Anarchy Radio. So we'll be right back. Don't go away. Yes, welcome to the No State Project for January 20th, 2018, here live from the Fortified Compound in San Bernardino, California. And we're here live every Saturday from 4 to 7 Eastern Standard Time on the Liberty Radio Network. That is LRN.FM. Every Saturday from 4 to 7, you'll find us here, and it'll be 1 to 4. Yeah, for me right now, though, it's here in California. And it's Sunday morning if you're down under, and I appreciate you guys tuning in. Appreciate Matt's support of the show. Continue support of the show. I do appreciate it, mate. I'm not going to give the number out because we have a full line of calls that we're going to get to. I'll get back to Joe in just a moment. The idea, people, think about it. What kind of person questions a man's sanity just because he's questioning if jurisdiction is an element of the charge? Why not just say yes or no and answer the question? You put a man in solitary confinement, basically. You put him on a suicide watch. Why? Because he had the audacity to challenge some lawyer? Welcome back, Joe. Do you remember where we were?
I just started off on something new before the break. I can't remember what it was.
I usually write that stuff down, but I got a lot going on here this weekend. Like I was saying, though, what we were talking about was how crazy it is, where just you can see just how dishonest things are when you're just asking for evidence and a psychological evaluation. I mean, it would be questionable at best, or at least if somebody was just asking for proof that 1 + 1 = 2. Like, what? You could prove that. I mean, you could just go through the steps. You could do it on your hands. And the idea that you question someone's sanity because they're asking for proof, I mean, kaba funko, these people. How much more proof do we need that these people are crooks? I would certainly recommend doing a claim against the Tarrant County risk management, the ones who are actually holding him there against what this judge did. Oh, I'm sorry. I should have written this down. I hate when I do that. What is that? The judge's name is Cheril Hardy. I'm going to write that down.
Cheril Hardy, yeah.
Cheril Hardy. That is one sick individual. Look, I know we haven't had success with this yet. I'm hoping that when you have something as egregious as this, so it doesn't just go to risk management, it should also go to the county commissioners, knowing that this woman is so dishonest and so power hungry. She's willing to put a man not accused of any harm. Let's make this clear. He's not accused of hurting anybody. He's a peaceful guy. And she's ordering a not only incarceration, she's ordering a psychological evaluation. She's questioning the man's sanity because he's questioning the required evidentiary basis that the prosecution has for their claim.
She has no training in psychology. She has no expert witness in the room. She's keeping him in a prison cell and taking away any avenue of release. Now, it's extremely unpopular for people to conceive of, wait, is it possible that the country I live in no longer has anything to do with actual freedom where the rubber meets the road? I mean, this is the most minor of traffic court, quote-unquote, violations, and this is happening. It's not easy for people to digest this, that I live in something that is just a few steps away from Nazi Germany and people dying. But I don't see how people, if they have the courage to take an honest look at the situation, how they can come to any other conclusion. I don't like that feeling it puts in my stomach either, but I honestly, sincerely, I'm like, oh, I'm within the borders claimed as the United States of America. I'm in deep shit. I'm sorry. Sorry for the language.
No, that's okay. Look, this is
what I mean?
This is an emotional issue. It gets at least gets my Sicilian going because these are real people. Bao is a real person in a lay sense, and to have someone, this Cheril Hardy, be so callous. And even if you are like one of the critics, Joe, and you say, "Look, Mark, look, the prosecution does have evidence; they can prove it, but it's a trial." Even if you take that stance, that is still, even just asking for the evidence they're supposed to have and holding them to their burden of proof is not grounds to question someone's sanity. This is purely punitive. This is a woman on a power trip. This is somebody, I'm not going to say she's a sociopath or a psychopath because this is only one example, but it is certainly exhibiting psychopathic tendencies in that she's doing something that is so callous, and she's doing it apparently so easily.
Oh, sure.
And for something so... Look, you've got people in for real crimes that are treated better. You've got people in Texas that, let's say, the kid who killed somebody and the judge didn't incarcerate him because he was rich and didn't think he would handle prison well. Right?
Yeah, it seems to be getting worse and worse.
He killed somebody. Yeah. And this one, he did less time than Bao was doing.
Yeah. Well, see, if you look, I can think of a few historical examples where the governments were basically more or less just like ours, but advanced in the tyranny category a few more steps. And what you see is that the corrupt state considers those who challenge its authority with logic and reason as the most dangerous members of society, far more dangerous to the state than actual thieves, robbers, and rapists. In fact, those thieves, robbers, and rapists have, in the past, been paroled out of jail, given a billy club, a pardon, and said, if you will serve the state and go take care of our security needs, you're good. And they know that that actual legit criminal will take them up on it. Now, I don't want to say, oh, that could happen in the U.S. and, people accuse me of being some kind of fear-mongering. I'm just looking at historical examples in the past to point that your point is valid and correct. I do believe they consider us a bigger threat to their sustained continued power than people who actually commit violent crimes.
Oh, sure.
I think it's easy to call this judge antisocial because she's working against society, especially with a guy like Bao. He's like the nicest guy. He works hard. He's from Vietnam, and he's the ideal type of person we want here. A net positive taxpayer, big time, for whatever that's worth. You know what I mean? Like, they don't, I'm considering from their point of view, they don't have a reason to come down on a guy like this, except for the fact that he does what is in his best interest instead of what's in their best interest. Well, and you've got a courtroom full of people who are accepting paychecks for doing exactly that. He doesn't all their face.
And look what they did to Robbie. From what I know about him, is just a kind-hearted, just a very easygoing, peaceful guy. And look what they did to him. So, so there you can see, these examples, and someone like Jermaine, where you can see people who are very upbeat, easygoing, very nonviolent type of people, very gentle type of people. Even when they're not accused of any criminal behavior, I mean, as far as violent and hurtful, that they haven't harmed anybody, to the extreme the actions that they take against such non-violent people. So for them to take such an extreme position and do what they're doing to someone who's not violent, it lends a lot of credibility. I think the circumstantial evidence is, well, look, what do they consider dangerous? It's not their behavior. It must be their challenge. It must be their words, because it certainly isn't their behavior. We're completely out of time for this segment. I do appreciate the call, Joe.
Sure, anytime. It's been too long. It's good to talk to you again, Mark.
Yeah, it was good to talk with you. Appreciate it. We've got a full boat of calls here on the No State Project, so we'll get to that in the next segment. So I do appreciate everyone's patience. I'm not going to give the number out, at least for a while, because we do have so many. So we'll be back with your calls and in just a moment, so don't go away. Yes, welcome back to the No State Project. I'm your host, Mark Stevens. The website, of course, is markstevens.net. I'm glad to be with you here today. And I think I was right earlier when I mentioned about the affluenza kid, Ethan Couch. It was Texas. So here you've got someone who was given 10 years probation after he killed 4 people and injured 2 in a 2013 accident. Drunk driving. Killed 4 people and injured 2. Was given no jail time. Now, he did, a number of years later, did violate the probation and has since fled to Mexico, and then I think he's sitting in prison now. But what is disgraceful... This is the so-called justice system. This guy got no jail time initially, and he killed people. He killed people. All Bao did was go into court and ask some questions, questioning the prosecution's complaint, questioning whether they've met their burden. And he's doing time. Thanks, Cheryl Hardy. That's what you get in Texas. You're better off killing somebody. If you want to avoid jail time, and you're better off killing somebody than asking any questions regarding their precious little system. That is quite something. So wow, that's Texas for you, everybody. Texas, and they also lead the United States in what do you call? I think they may even lead the world as far as executions per capita. So at least the United States, I know that's correct. So anyway. Let's get to your calls. We have a newer caller here. We have area code 626. You're live on the No State Project. What's your name? Where are you calling from? Hey, area code 626. You're live on the show. Okay, so we're going to mute them back up. We got area code 973. You're live on the No State Project. What's your name? Where are you calling from? I'm pretty certain that I've got things right. Let me see. Okay, I don't think that is that. I don't know. Okay, we'll have to mute that up. That's really odd. For some reason, I'm not getting any audio from my caller line. So we'll try that again. Huh. All right. We'll try area code 509. That is really odd. All right. I don't know what the problem is there. All right. Well, let's get into, well, all right. Well, okay. Would it be the No State Project without a technical issue? All that was done before the show. So let me see if I got... We're not on hold anymore. No. All right, I'll get that straightened out. And I should be able to get this all edited out for the podcast, which will be up at markstevens.net. I don't know if it'll be today, but we'll definitely get it up there. We're talking about, well, and there was a government shutdown. That was a federal government shutdown, so that's always good news. We'll see what happens with that. All the scare tactics, people will die and whatnot. Yeah, it's the same thing every time. Wow. Okay, so the habeas corpus. I wanted to discuss that because not everybody knows what the habeas corpus is about. So the habeas corpus goes back years and years and years, and it means in Latin, bring the body. And the habeas corpus is used and has been used for anyone in the realm to test the sufficiency of an arrest or a restraint on someone's liberty. So if you go and you look at the statutes that govern the habeas corpus petitions, they can be filed by anybody on anyone's behalf. Of course, the feds don't like that at all. They say that you have to show that you have their best interest. And I think the fact that you are filing a habeas corpus is evidence enough that you have their best interest there. So you're trying to get them out of jail from an illegal imprisonment. So that seems to cover that. You know, you're not the one that's putting them on a suicide watch and questioning their sanity. So it is directed, of course, the plaintiff will be the one who's actually holding. So here, Cheril Hardy, even though she is the psychopath or sociopathic leaning criminal who did this to Bao, she is not the plaintiff, the defendant. She's not the defendant. So the defendant is always the one who's actually holding the individual against their will, the restraint on their liberty. So in Bao's case, let me see what we got here. For Bao's case, it is the Lon Evans correction, and Paul S. Patterson is the building manager. Actually, the sheriff's office is going to be the one. That's typically the way it is. Like in Arizona, in Phoenix, it was always Joe Arpaio is the defendant because they're the ones that are actually holding them. And so the writ, if they act on it and they issue an order for, to bring the prisoner into court, Joe Arpaio, the sheriff who's ever holding responsible for him being held, has to bring them into court and show evidence and a legal justification to show why they are holding them and that it is justified. So in Bao's case, what this sheriff is going to have to do, if they act on the petition for the writ, they will have to show that not only is there evidence to show jurisdiction to hold him at all, they're going to have to show evidence to justify a psych evaluation, which, gotta tell you, I really don't see that in any shape or form, because the only thing they have is that he's asking questions. He's asking, the question that did it was if jurisdiction is an element of the charge, which of course it is, which is, it's a trial issue. Most of the time they will agree that jurisdiction's a trial issue. So just asking them to confirm whether that's true or not, yeah, I'm gonna go ahead and take a risk here. And I'm gonna say that asking if jurisdiction's an element of the charge, no, not sufficient grounds or grounds at all to suggest that somebody is mentally unstable or needs a psychological evaluation. I think what we've got here is this Cheryl Hardy's just a crook who doesn't like being challenged and doesn't like being asked questions. So the only one who should be getting a psychological evaluation is her, to explain why she's putting a peaceful man in jail. But then we'll be back, and I'll try to fix the call line when we get back in just a moment. Yes, welcome back. Listening to the No State Project. If you're being attacked by a bureaucrat, you want to learn how to effectively defend yourself. You just want to learn to be able to, counter someone's argument, show where the argument is flawed by using the Socratic method. Then you can get a full model on how to really just wreck somebody's claim and show that it's invalid or that they're lying. In Government Indicted, you can also get a lot more information about effectively defending yourself in and out of court. Again, that's markstevens.net. And I think I've got the caller line straight now. I don't know what happened. I mean, things happen. So, hey, what do you, so we'll try again. We have area code 626. You're live on the No State Project. What's your name? Where are you calling from?
Hi, I'm Errol Alexander, calling from Riverside, California.
Oh, look at that. Hey, not too far from me.
Yeah, not too far. I've been listening to you for about an hour and a half now.
Well, you've been patient. I do appreciate it. I'm doing good. I appreciate the patience. What we got for you today?
Okay, yeah. I recently got a traffic ticket, and I've just been extending it, so I have a date, and I wanted to use the no plea rule like you have said. I've been researching it online, but I've never done this, and I don't even know where to start. So
I'm glad you called. It's more people. I hope start calling that. So instead of just trying to learn everything on their own, that they get some guidance. Yeah. And so, are you familiar with the basic premise of how we challenge things here?
Yes.
Okay. Well, what we always do is we start off with the demur, and a demur is it used to always be called a demur, but most places now call it a motion to dismiss, where you're asking the court to dismiss because there are the complaint is not sufficient for the court to proceed on it, to acquire jurisdiction, or that the plaintiff has not filed the sufficient facts. And so a demur in California is governed under Section 1001 of the California Criminal Code. And so one of the reasons why you would file a demur and why a demur would be granted and a ticket dismissed or thrown out is that the plaintiff has not filed or pled sufficient facts to set forth an offense. And my position is that just saying you broke the law is not sufficient, or just saying you're in California is insufficient to set forth an actual offense, because they're assuming the most important element, and that is that the rules or the laws apply to you already, and that you violated them by doing X, Y, Z. And that's why that's what we set forth in a demur. And that's because the basic principles of logic dictate, and this is also true in court, that the one who makes the accusation bears the burden of proof. And that's why the demur the 1001 will say there's insufficient facts. So you have to look at the complaint filed by anybody. Do the facts alleged, if taken as true, prove that the offense was committed? And here, there aren't any facts to show that the Constitution and laws apply just because you're physically in California. They're assuming that. So absolutely, it's clear that the facts as pled do not set forth, if taken as true, do not prove that you committed the offense.
Okay.
Right.
Now, as far as filing a demur, is that something I have to do in court or when I first go? That's my whole thing. I have never been to a court or done anything like that. Wait, Mama. So that's my question. Where do I start? Do I file paperwork at the court, and where do I go from there?
Okay, I really envy you because you've never had to do this before. So my hat's off to you, my friend. And living out in California, you've dodged that for a while. Okay, the demur is in writing, and I do have a template for that. And we do send now for you and for those listening. I always do send the instructions when you order that, but I'll go through it here on the air.
Okay.
The demur is in writing, of course, and it goes with a discovery request. And California is different than most places, which is why we do a request for judicial notice for the points that we're raising in the demur. Okay, so what we do with anything that we file, we're always, of course, sending it to the clerk of the court that the complaint was filed into. So let's just say it's the Riverside Superior Court, just for the hell of it, okay? So it's going to go to the clerk of the Superior Court. A copy of everything you file has to be sent to opposing counsel or the opposing party. So here it may just be, it's going to say State of California, and at this point you may only have a police officer. There may not be a prosecutor. So in the certificate of service, which is the last page of the demur, you would put the police officer's name and badge number and his address at the police department because you're going to send copies to them. All right?
Okay.
Now, as long as there's no prosecutor, you're good doing it that way. Once you find out that there is a prosecutor assigned to the case, or the complaint rather, then you have to send everything to the prosecutor and have no contact whatsoever with the police officer.
Okay.
Now, they may or may not set the demur for a hearing, or they may hear it, let's say, at an initial appearance. So an initial appearance is the same thing as an arraignment where you're expected to enter a plea of guilty or not guilty. Now, the demur actually takes the place of, or at least preempts you having to enter a plea. The demur has to be disposed of first. Then if it's overruled, meaning the judge is denying it, then he's going to expect you to enter a plea, and we want to still discuss the demur rather, before discussing a plea.
Okay.
And so I do recommend, and I have a script for this, but I do recommend that
where could I order the demur from you? That's what I'm with the script and all that, so... That's on your website?
It's on my website. The best, I do have to, make it a little, streamline that a bit. The best place to get it is to use the Sells button, which you can still get under my store. It's a much better way to order it than, it's an easier way than getting it on PayPal, but you can still use PayPal. Okay. And so what we recommend is doing role playing. So when you're probably going to have to go in, is to be able to defend the demur and ask appropriate questions and make appropriate objections if the judge is going to just overrule it without explanation.
Okay. Yeah. I have that part of where you watch your video on the plea of not guilty, and has the prosecutor provided evidence of that the constitutional laws of the plaintiff state actually applies to me. And so after I ask that, if he says he have evidence, then where do I go from there? If he says he has evidence, the judge.
Well, this is the beauty of the Socratic method. If he's saying that the prosecutor has met his burden, you want to know what exactly he's talking to. He says, so you can ask. So you're saying the evidence is in the complaint?
Yeah. Oh, okay.
He may even say that he had, because typically they dodge the question and they ask you a question in return. So he'll ask you that, don't you have the complaint? To which we would then respond with, is it your position that the prosecution's evidence is in the complaint? And from there, it's easy. So when they say that, yes, and well, then, dude, what are you talking about? Yeah. Can you please cite that?
Yeah, okay. All right. Yeah, that was my big question, because I didn't know what if he said yes and where I go from there. Okay.
You have a written instrument. You have the ticket. There's not much wiggle room for him to go to. Yeah. It's very specific, in that they don't like to be specific. So let me just mute you up for a second. We'll finish on the other side. My name is Mark Stevens. You're listening to the No State Project here on the Liberty Radio Network, discussing the basics. What do we do? Have we never been to court before? How do we go about doing this? Do I file this? So we'll cover a bit more of that with Earl from Riverside when we get back in just a few moments. So don't go away. Yes, welcome back to the No State Project. I'm your host, Mark Stevens. Taking your calls. I'll put that up there again if there's anyone who wants to call in. We may have enough time. It's 218-632-9399. 218-632-9399. The passcode is 2020. You can also reach me at Skype at FrankRizzo3. Please instant message me first. And just because it came up, in Libertopia, 2018, it's only a few months away, in San Diego from May 3rd to May 6th. Definitely go to libertopia.org and sign up today. I'd love to see you out there. And because it came up here on the No State Project Skype chat, if there is a broken link on my wiki page, please either email me at markstevens@mail.com, or you can Skype it to me at FrankRizzo3, and I'll get that taken care of. I have to update the success story page, and I probably haven't done that in 3 years. So I do have a lot of work that I need to do on that. So I'll get right on that. I want to welcome back to the show Earl from Riverside. So did you have any other questions regarding what the basics on what we need to do to file it appropriately? And real quick before you can mail everything in to the clerk of the court. You don't actually have to go down there.
Oh, okay. Well, I kind of work in the county, so I have to. I pass by it every day, so it'll be a quick stop by for me. But as after the demur, as far those are filed. Now, as far as filing it, do I have a amount of time I have to do to file it? Because my court case is next Thursday. I have to be at court by the 25th. So, like I said, I'm trying to see what paperwork I need to file within before I actually go to my arraignment.
Get it filed as soon as you can before that arraignment.
Okay. Okay. And so for like you said, the first thing is the demur, and from there the right to facts, right?
Well, you're doing the demur, which is based on a lack of facts, lack of evidence, which is why if the judge denies it, this is part of the role playing. If the judge denies it, you object and ask him if his position is that the prosecution has met their evidentiary burden, because it's the only way to overcome the demur.
Okay.
That is going with a motion for judicial notice, which is mandatory when you give him the information. And here in California, they take judicial notice of court rulings, such as the United States court system, federal and state, is adversarial, and that adversary proceedings require the allegation and evidence of an injury, a legal injury. Because we have that in a demur, that and other points that the where the prosecution is supposed to have evidence, to make it more difficult for the judge to just outright deny it, we ask for judicial notice. So it makes it a lot more difficult for a judge to overrule the demur, and and if he has to take judicial notice that it is an adversarial system, and an adversarial system requires an antagonistic assertion of rights, which they haven't done. So if he agrees that it does require, and the law does, and that's what they're supposed to take notice of, if they take notice that there's a requirement for the violation of a legal right, and they don't have that, and they don't have any evidence, it's more difficult for him to try to explain. In fact, it's impossible for him to explain why he's denying the demur. Okay. So we also do the request for discovery and Brady material, because we want to know, first and foremost, the evidence the prosecution has to support their main claim, which is that their laws apply because you're physically in California, and we want to know the name of a witness with personal knowledge. Now, I just spoke with a Sarah Richard. What's her name? Sarah Richards. She's a lieutenant with the police department up in Northern California, the CHP, and she stated under oath on a discovery request response that the officer did have personal knowledge that the Constitution applied, and claimed that the driver's license was the evidence. But when I called to speak to her about it, she said, and I think this was Thursday, she said that after speaking to her counsel, her lawyers, she has been told not to speak to me or anyone else regarding this matter, and to just that we can ask the questions at trial.
Oh, okay.
So they may pull that, but here you're going to an arraignment. You have every opportunity here to ask the judge for the prosecution's evidence. So those are the three documents we're initially filing. So again, you go to the clerk of the court and you mail copies to the police officer at the police department.
Okay. All right. Now, as far as your website for getting the demur, is it under the heading demur if I search for it? Is it under the motion to dismiss?
It's probably under motion to dismiss, but demur may be in there. But the motion is to dismiss is what you're looking for.
Okay, motion to dismiss. Okay. Okay, I will get on that right now because I need that in by Monday.
Yeah.
To be in. Yeah.
Yeah.
And then I'll be up there on Saturday. And you said that, it wouldn't make sense to mail it because I don't have that much time. Right.
Yeah, they may get it. I mean, if you're in Riverside and you're mailing it from Riverside, they'll get it the next day. So if you mail it Monday, they'll have it Tuesday. And honestly, I know they may try to turn around and say that the prosecution, you may go there next week and the judge will say, look, I got you demur. I can't make a decision on this yet. The prosecution hasn't had time to respond to it. We spoke about this on a show not too long ago, so I don't want to belabor the point much too here, but here you can just say, sir, I understand that, but I still have to object. Either the evidence is on the record or it's not. This is not a murder trial. This is not rape. This is a simple traffic ticket. If the evidence is not in the record right now, you can sustain the demur and give them leave to amend if you want, but you can still make a decision.
Okay.
Because hey, you can say, and if he doesn't want to do that, you say, you know what? I'm still willing to plead guilty right now if the prosecution has met their burden. And so you, like I discussed in the video, you can still make that look, we can just avoid the demur right now if you want, sir. If you want to play it that way, that's fine. I'm still willing to plead guilty if they've met their prima facie burden. Okay. And so you're still pressing the issue.
Yeah. Okay. All right. So now, I've been watching a lot of other videos, and that's how I came up on you, because a lot of people were basically saying your name, and I was like, Mark, I'm trying to find your name, but I was spelling it wrong the whole time because I was putting M-A-R-K, so Mark Stevenson. So I was like, so finally I found you, and it's almost deadline when I found the best information I'm getting from you, basically, and so it's just overwhelming because I only have like a couple of days to get prepped for this and stuff right now. But as far as I was watching another video that said they were saying something about the word subrogation. Do you know what they're talking about? It has to do with equity and switching the creditor. I was just watching about that. They say you could use that in court to basically settle the charges against you.
You know, this
do
has been
you
going
know?
around, and some people have mentioned it to me, and I've seen no evidence that this is actually true.
Oh, okay.
That somebody's gone into court and been able to get something kicked out.
Yeah.
You know, what I know of subrogation has to do with somebody acting on behalf of another party.
Yeah.
But from what you know, and then I've heard about what you're saying, and I every week somebody contacts me about that, and Facebook, and just my position is, show me the evidence. And you know that you've actually done it. Prove that this is true. It's just like someone claiming that he recused every single judge in the state of California or the Orange County, and just show me the documentation. Prove it. And he has never gotten back to me on that. So, well, he's not presented the evidence. He just claims it's 30 years old or 25 years old, and he just hasn't been able to go through all the boxes. So,
Okay.
yeah.
All right.
I think the best thing, well, real quick, before we're pretty much out of time for the segment, I think the best thing, the most effective way to do it is to just challenge the arguments or the claims that are being made against you. Hold them to their burden of proof, because if they had the evidence, they would just present it, right?
Exactly. All right. That's
Well, hey.
exactly what I'll do. That's like I said, that's the best.
All right, Earl.
So
I appreciate the call. My name is Mark Stevens. Stay in touch. Let me know how it goes next week, so you can call in next Saturday. And I'd like to, hey, maybe we have some good news from you. We'll be back with the third of 3 hours of Anarchy Radio here on LRN.FM in just a moment, so don't go anywhere. Welcome back. You're listening to the No State Project here on LRN.FM. 3 hours of Anarchy Radio. This is the third of 3 hours, and by anarchy we mean no rulers. Not no rules, no rulers. And we reject the idea that we need to have a violent ruling class, because, hey, that's how you get a ruling class, a violent ruling class. And when you have a prison system with over 2 million people in there, you have no argument that it's not a violent ruling class. We do believe that the principle of do no harm applies to all. Live honestly, injure no one, give every man his due. Applies to everybody. And no, morality is not subjective. It is not something that's just a human construct. It is actually based on objective reality. It comes from the fact that we have empathy, that it hurts us to see other people in pain. That is the basis of a moral system. Unless you're a psychopath like Cheril S or engages in psychopathic type behavior or a callous disregard for other people, and to treat other people like pawns in chess. You have empathy, and that forms the basis of our moral code. And that can be registered. That could be. You can see the part of the brain in a scan that lights up when we're feeling empathy. That's objective proof. No, not everybody has empathy. A very small percentage of the population does not. But that is still the basis of our moral code of do no harm. Should apply to everybody. Even this Cheril S. Just because she calls herself a judge, calls herself the government, doesn't mean that what she's doing is not morally reprehensible, and she should not be held to some account there. So there should definitely be, in addition to the habeas corpus, a complaint, a claim against their insurance, complaints filed. Let the city council know, or the county commissioners, let them know about this woman. It's got to be more than just a YouTube video that I do with her name in the title. But I want to get to your calls. We have area code 973. You're live on the No Say Project. What's your name? Where are you calling from? I'm not getting anything again. Is this going to be a regular thing? All right. I've been very patient, though. Area code 973. Shout it out. Okay. We'll try area code 509. You're live on the No State Project. What's your name? Where are you calling from? You called a long time.
Hello, am I on?
Yeah, you're on. What's your name? Where are you calling from?
Maxwell Taylor from Pomeroy, Washington.
Maxwell from Washington. What can I do for you today? You got good news?
It's all right. I'm being brought up on some criminal charges for allegedly wasting some wildlife, and I've been, doing research on how to challenge jurisdiction, and now I'm going in on my third arraignment, or being called in for the third time for arraignment because I'm not willing to plea because they haven't proven jurisdiction. I was curious whether or not there is any such proof of jurisdiction that I'd be able to find that they'd be able to, prove that they had. They tried to claim the ticket that I got was proof of jurisdiction.
Did you ask them to cite exactly what it was on the ticket that proved that the Constitution and Code apply just because you were physically in Washington?
No, I haven't yet. Like I said, the first time I went in for the arraignment, I had just got discovery, so I had asked them to extend the arraignment so I could go over everything and learn a little bit more before I tried to represent myself. So the second time I tried to challenge jurisdiction, he told me that the ticket was proof of jurisdiction, tried to put in a plea for me, and I objected and told him that he was just, practicing law behind the bench.
You see, we got a lot of things to unpack here there, Maxwell. We don't refuse to plea. We are willing to plead guilty if the prosecution has met their prima facie burden, and we don't make statements like you're doing. We always object and use questions. I'm concerned. Wasting wildlife. What is that? What does that mean?
Oh, I had a deer that went bad. That I would kill in the process of cutting it up, letting it hang out, cure or whatever. It got real bad, and I wasn't able to use it. So I was going to use it for a coyote bait rather than eat it myself. And then the owner of one of my buddy's places that he was renting, in his process of moving out, called the game warden over, and I had to deal with him. But he'd looking into the RCWs of the statutes of tenant law, he'd broken a few different laws, tenant laws in that sense. He never produced a warrant of any kind to even seize my property, and they're trying to charge me under a commercial statute on RCW 77-15-170, and basically, the whole thing has to do with commercial use of meat. Like if I would have taken that into a professional meat cutter and never went to pick it up or something, it's technically what this statute applies to, but I'm not a commercial entity, and that was my private property, and so it's kind of irritating.
Well, this is one of those situations where I got to say where being a vegan would have definitely helped you avoid all this trouble.
Yeah, more than likely.
Well, I would definitely consider that the whole thing about do no harm and empathy and not causing unnecessary harm. However, what's really good here is you have the judge, out of desperation, I think anyway, gets very specific with you and saying something he can't possibly back up. He said the ticket was the evidence. So you can use his own statement against him. So if you go in there again, and don't say you won't plea. I say, look, if I have to plea, I'll plead guilty if the prosecution has met their prima facie burden. Would you ask him, sir, before you stated that the evidence of jurisdiction, that the Constitution and laws apply to me because I'm physically in Washington, is on the ticket, could you please cite it for me? I have a copy here. What are you talking about?
Mm-hmm.
Okay, because getting back to what you said before, are you under the impression that the judge could somehow produce evidence proving the Constitution and Code apply because you're in Washington?
No, I don't think so, no.
Yeah, it's not a matter for you to research and find it and then try to have to deal with that. There is no evidence. In fact, that's why critics will say I'm an idiot because I'm asking for evidence where evidence is not necessary. Well, that's just not true, because we know that you and we're not allowed to make legal claims without evidence, right?
Mm-hmm.
Well, then why would the prosecution be allowed to do that? So if there was evidence, they would produce it. And so I've actually confronted a sitting Supreme Court Chief Justice and asked him for evidence of that the code applied, because I was physically in Arizona and I was standing in the ASU law school at the time. And the best that he can do is say that the evidence proving the laws applied to me or the other people that he put in prison.
Huh. Well, how would you go on pressing that then without being held in contempt of him just being tired of you, essentially? You know what I mean?
Well, yeah. This has been a pretty big show regarding that. I would ask him, we'll get back to our role play, on the other side of the break, but I would ask him for the specifics. What specific facts on this ticket lead you to believe that the Constitution applies to me? So let me mute you up. We'll be back in just a few minutes here on the No State Project, so don't go away. We're talking with Maxwell in Washington. How does a judge respond to something like that? Well, we'll get back to that in just a moment, so don't go away. Yes, welcome back to the No State Project. I'm your host, Mark Stevens, author of Government Indicted. Again, if you're being attacked by a bureaucrat, you want to learn how an effective, proven way that's been replicated many times on 3 continents, including in Israel. Go to markstevens.net, get a copy of Government Indicted, check out the archives, and the articles, the videos. I am almost at 10,000 subs on YouTube, which for a channel like mine is huge. I'd say it's bigly, that's for sure. But I'm very, very close to getting 10,000 subs. So if you're not subbed, check it out, because we do the Wednesday broadcast commercial free on my YouTube channel. So if you want the notification when we're having new shows, and I will be live on Wednesday. I had to miss this past Wednesday, but we got this one coming up. So if there's anybody we miss here today, check out the Wednesday broadcast on my YouTube channel, which is at 4 Mountain Standard Time over here. So definitely check that out. I want to bring back Maxwell in Washington, and
how's it going?
Yeah, it was good. I'm glad that it's a good question that you're asking. Well, what do we do if you're saying, how's the judge going to respond, or how do we respond when the judge says that the evidence, alleged evidence is on the ticket? You want him to cite it. Just have him be specific. So keep in mind that what we're doing is asking them to be more and more specific. This is not the Freeman sovereign type thing of just asking for more and more authority.
Yeah.
We're asking them to be more specific with the statements that they're making or the answers that they're giving. And if they're being vague, we want them to be more specific. And that's really what undoes this for them. That's the way how you can usually show that someone's lying, is to get more and more specific. You have them be more specific with the answers they're giving. So when the judge gives a more specific, though still vague answer, that the ticket, you want to be more specific. You want him more specific, so you ask him, well, objection, sir, I don't know what you're talking about. What on this ticket proves your Constitution applies to me?
Yeah, that makes total sense.
Now, what can he say? What could he possibly say to that?
Yeah, other than try and pull me off of that question, try and move me somewhere else, take my mind off it, I can't really see him having an answer.
The best he can do, if he's a sort of a decent guy still, is to say, "You're here. It's right there. You're in Washington." And so when they say something like that, how should we respond?
Where's the proof of that? Where's the proof that that's true?
You're right here. They have a prima facie, the prosecution, which is you brought up, sir, the prima facie burden. The prima facie burden is the stated facts, if taken as true. Okay, now, he's stating that you're physically in Washington. I have to accept that as true at this point. And so that's what I have. So now it's your turn. How do you respond? So he's just saying he's got a statement from the police officer, an eyewitness, that you were physically in Washington.
Okay, and then I would ask, well, where's the proof that the laws apply to me just because I'm physically here?
Yeah, well,
right?
Yeah, that's what you're getting at, because and your objection could be objection, and this is a leading question. You want to ask leading questions, which is putting the context in the question that you're trying to bring out. Objection, isn't that just restating the prosecution's claim? We already know they're claiming the laws apply because I'm physically in Washington. We already know that. I'm asking you for the actual proof that that's true.
Okay, so they're just restating it and just object to them saying the same thing, essentially.
Right.
Proof.
Right. Now, the technical phrase from logic would be it's a proof by assertion fallacy. They just keep repeating it as if it's true. But, sir, you're here. Yeah, I understand. How, in what way does that prove your Constitution applies to me? I love that it's Washington, because I actually have this on a number of years ago where I spoke to a prosecutor in Washington, and she broke down and says, I said, exactly how does the physically being in Washington prove your Constitution applies? And she goes, it just does.
Yeah, that seems to be the mentality.
Oh, in their defense, though, they have a prison system, so you don't really have to support what you're saying when you have a prison system. But as far as what you're going through here, is the judge going to say it just does? No, of course not. They don't say things like that in court, where there's a record that the higher judges, who may just affirm what they're doing, but will get a good chuckle and make fun of them if you really said that. You got to do a little better than that, Dad. So for here, the judge more than likely at this particular point is just going to say, we're moving on. We're moving on. And, this is where the role-playing helps. Even if you're not at trial, you still need to do these things at arraignment and pretrial to avoid trial, so you could possibly avoid trial. So here at this point, we want to always make an objection. Well, objection, I don't think, so it's your position. I don't understand here, sir. You're going to move forward without any evidence?
Oh, yeah.
And he may say, I'm satisfied that we have sufficient evidence. Well, objection, exactly. Again, we're at the same point, sir. Exactly how does my physical location prove that this Constitution, a written instrument, applies to me?
So I just keep pressing that until he gets tired enough of me and tries to hold me in contempt.
Well, we don't want that. If you're an activist, then maybe you want to push it to he starts to threaten you, and then kind of back off once you get the threat, and you say, "Whoa, I understand. If I try to defend myself, you're going to threaten me." Or you can say, "Well, objection. Why are you threatening me just for asking about the prosecution's evidence?" Now, you probably get the same stupid. We've already covered this, or I've already made my decision. But you didn't make a decision based on the facts. See, typically what happens, and I say this a lot, I get this, the judge will insist that he has jurisdiction, and that's when we object and say, is that because the prosecution's evidence says so, or because you say so? You want to separate the two. What's he basing his argument or his decision on? The evidence, or just because it's what he says?
Or collusion with the prosecution,
Yes. We may not be able to prove collusion, but we can certainly show that the judge is carrying the water for the prosecution.
Yeah.
That's easy to show, because he's not holding the prosecution to their burden. Now, there's one particular critic that would say, well, if you don't accept the judge's position and you keep going, now you're arguing philosophy, and that's ridiculous. Asking for the prosecution's evidence is not asking for... it's not arguing philosophy. We're totally out of time for this segment. Did you have any other questions?
At the moment...
You know what? Just hold on. I'll put you on hold. We'll be back. We'll finish up with Maxwell and get to your calls in just a few moments here on the No Stay Project. So don't go anywhere. We still got a lot of stuff to get to. Yes, welcome back to the No State Project. That happens to be Caffeine Carl Wagner on that second guitar there, so he's also still quite active in the blues scene down there in Key West, so if you're down there, definitely check out Carl Wagner. Caffeine Carl Wagner. So welcome back to the big show here. We only have a couple segments left, so we're going to do what we can to jam as much information in as we can. And remember, whatever we don't get to today, we can hit the no commercial version, the live stream on my YouTube channel on Wednesday, 4 p.m. Mountain Standard Time. Same calling numbers, all that. Welcome back, Maxwell from Washington. So, what other questions or concerns that might you have for prepping for this?
So you were saying that I'd be prepared to plead guilty. Would I be able to be prepared to plead not guilty if I had to plead?
I don't think we need to do that, because if he refuses to allow you to plead guilty and will not hold the prosecution to their burden of proof, he's just going to plead not guilty for you, and then we want to move to have that stricken because of all, he's lying. He's now giving you direct evidence to show that he's lying. And for those who are new, the reason why I say the judge is lying is because the judge can only plead not guilty if you're refusing to plea, and so you're going to have in the record an unsigned plea of guilty, which stands as evidence against the judge that you're not refusing to plea. And it's not a conditional plea, as I've said before, because you're only asking if the prosecution has met their burden so far, which they have to do anyway. So whether you ask or not, the judge is on the hook. He's responsible to know and look at the record and determine if there's sufficient evidence to prove that they have jurisdiction to proceed.
But he's gonna believe that, or at least push that he does, and I'm just gonna have to keep keep objecting until I kind of get my way, I guess, and keep pushing for proof.
Well, yeah, I mean,
plead guilty.
That all we can do is show that the process is grossly unfair, and we do that with the objections and offering to plead guilty. I mean, really. I mean, come on, guys. Let's. There's no pretense here. For what reason? You're not accused of murder. You're not. This isn't a rape. This is a minor thing. This isn't a complicated situation where you're looking at 30, 40, or 50 years in jail, like that prick in Texas should have gotten. Why won't they let us? Why won't they even entertain the idea of pleading guilty? Why? When 90% plus are always pled. Why, when we come in, is it universally not allowed? Somebody please explain why they won't allow us to plead guilty. I understand why. Someone give me a counter argument. My position is they know the prosecution doesn't have the evidence, so they don't allow it. They don't even entertain it. It's the only rational explanation. The evidence is on the table. 90% plus of all complaints end in a plea agreement. Why won't they let me? Why won't they let people I'm working with? They don't even entertain it. It's not like they say, go in the next room and you try to hash something out. They don't even allow it.
Yeah.
So that's because if the prosecution, look, if the prosecution had evidence, they would just present it. They don't, which is why they don't let us plead guilty. So it's your job to make those objections and let them know. You can even let them know. You say, look, I'm filing for discovery. I know their witness has to have personal knowledge. You're saying that you're not even going to disclose it. How can the witness have personal knowledge of something that's not disclosed? I said, I'm going to ask the police officer these questions on cross-examination. And the only thing you can do is commit the worst error you can as a judge and not allow cross-examination. And if that's the only way I can get this defeated is on appeal for a denial of cross-examination, then that's what I'll do. And you can telegraph all this stuff, and they'll do it anyway.
Mm-hmm.
They don't care. But I guarantee, this is one. If you ask the questions, the right questions, I'm not saying it's magic, but if you do the right leading questions, you will have. And I'll just for those who are new, the question is: did you determine on your own that just because I was physically in Washington that the Constitution applied and the laws, and there was jurisdiction to write me a ticket? Yep. The moment you ask him, what evidence, if any, do you have to support that claim? The prosecution will impeach their own witness, and the judge will agree to it. He's going to tell you in plain English the witness is not competent to give legal determinations or make legal claims, and that's exactly what he did when he wrote the ticket, right?
Yeah.
So what the judge is doing is not allowing you to cross-examine the witness on his prior statements. That is one of the worst errors the judge can commit. And it may come down to that's the only thing that you have going, that in the prosecutorial misconduct and lying about the plea that you have for the appeal.
Yeah. And when the judge, he told me that when the ticket was that's the proof of jurisdiction, I objected and said that that's not fair, because if this is proof of jurisdiction, then I should be able to go write a ticket to anyone and claim I have jurisdiction over them.
Yeah, I agree with what you're saying, but do you understand how, from a tactical standpoint, why that was bad?
Yeah, I kind of do. That was my first, this is my first time really ever having to do any of this, so I'm kind of learning along the way. But
okay, well, tell me what the tactical error was.
I showed him that I wasn't going to play his rules or play his games.
No. I already corrected you on this. Then. The tactical error you made was making a statement and not objecting and asking a leading question.
Okay.
You keep the burden on them. They're the ones who are saying this is fair. They're the ones that are saying that you're guilty of this, that, and the other thing. Keep the burden on them. If you make a statement, they'll just disagree with you. Well, sir, we disagree with you. And if you have to, you can appeal and raise that issue on appeal. But we disagree with you. So that's why asking a question is so much more effective, because you're keeping the burden on them, and they either answer or they don't. And some may argue, he doesn't have to answer. Really, isn't the foundation of a fair trial is notice and opportunity to defend, that they're supposed to inform you so that you can defend against it? And if they're not going to answer the question and they're not going to inform you, you can't possibly defend yourself. And if you can't defend yourself, it's not fair. So however they want to play it, you can show how unfair it is.
Okay.
So definitely,
that makes sense.
Yeah, get to the role playing. Have you filed a motion to dismiss yet?
I'm doing that Monday. I'll be putting that in Monday for file to dismiss, and I'll be. They don't really have in this court system here, this district court here in Garfield County. They don't have any paperwork to file for filming it myself, so I'm going to have to file in a request to record myself, to record in the courtroom myself. I'll be doing that as well to hopefully be able to, go over it myself and learn from my mistakes. If I'm sure I'll have some, so that way I can. Do better next time, hopefully.
Well, do the role playing. Call the show again. We'll do what we can to get you prepped, and maybe in the area, if you go on the forum or post on the No State Project Skype chat, maybe we've got someone near the area that can also help you out as a media rep and show up and let the judge know that they're there from the media, and maybe get them on better behavior so that you get maybe a couple more minutes of being able to question them. All right.
Yeah.
All right. Well, appreciate the call. We are out of time, so definitely stay in touch and let us know what we can do to help you. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM. We're going into the last segment of the big show for January 20th. Wow, it goes fast. So we'll be back in just a few moments, so don't go away. We got a little more. Yes, welcome back to the big show here. We're in the last segment for this January 20th, 2018 show, and I'll do my best to get this on markstevens.net today and then post it on my YouTube channel on Monday. But I am out of town, so please pardon if I am not able to do that. I can at least get the audio up at markstevens.net. So I'm going to try. He's been on hold almost the entire show, so I'm going to try again before trying someone else. We have area code 973. You're live on the No State Project. What's your name? Where you calling from? You've been on the...
Hey, Mark, can you...
Yes.
You can hear me? You can hear me?
I'm glad I got you. You're a very patient man.
Yes, sir. You're giving us some very important information that's worth waiting on.
Well, what was your name? Where are you calling from?
My name is James. I'm calling from Georgia.
James from Georgia. Well, what can I help you with today?
Well, to be honest with you, the gentleman who called in before kind of had some of the similar questions. Just a little brief background. I caught a few charges down here, some traffic, some felony, different cases. And I had a bond revocation hearing about 3 weeks ago. And I had been, challenging jurisdiction and going about it in processes that wasn't as streamlined as yours. And the Sunday, the night before my bond revocation hearing, literally like this time at night, the same video that the guy was talking about earlier, the supplication video, I seen it. Somebody said, hey, check out Mark Stevens. This is the way to go. I crammed that night. I went in. I already, objected to proceeding with them revoking my bond and arresting me, and I walked out of there with my freedom, so I would call that successful. And just since then, I've been following the show, and I've been, trying to get more familiar with the method. Where I'm at right now, I actually go to court next week. I have court dates, about 3 of them, for all my cases. The first one that's coming up is for the felony case. I actually got the packet from you with the templates for the motion to dismiss and the discovery and whatnot, and the script that you speak from in the courtroom. And I filed my motion to dismiss actually about 2 weeks ago. I know they received it because I sent the certified mail, and the motion to dismiss and the discovery. So when I go in there, this will be a superior court arraignment. And, like I said, I've done it. I've been in the courtroom 3 times so far. Every time I've always challenged jurisdiction. I never got none of that crazy stuff with the birth certificate and none of that. I always tried to argue jurisdiction. I just wasn't arguing it properly, like I said, until I found out about your situation. So when I go in there Monday to the superior court, I'm going in, I'm objecting to proceeding. I'm asking the judge to make a ruling on my motion that I have filed with the court that I know that you received over a week ago. And from there, I know, from doing it before, I'm kind of familiar with what they're going to try to do. So I know he's going to try to say something wrong. Hey, you can't argue that now. This is for trial. Or, hey, this isn't the time for this. You have to put in a plea right now. So I'm saying when
Really?
he gets to there, what would be, being that I've already filed my motions and whatnot, what would be the best question or which way to redirect him to making a ruling on my motions?
Well, you can object and say, well, objection, doesn't the motion have to be decided on prior to a plea? Yeah. That was my understanding. Like I said, I've been paying attention to everything you've been saying so far. Same thing. Like I went to a court appearance I had in another part of Georgia, and I kind of wanted to ask you about this. A friend of mine came with me, family member, and I've been, kind of crash coursing him about, what I've learned from you. And when we went in there, it was a little small town in Georgia, Woodbine, Georgia, to be exact. And I believe he was some type of administrator. He didn't have a gown on, no type of gown on as a judge. He had a T-shirt on, and no one had to rise and none of that. He was very on fire, like, hey, you guys plead guilty. I'm going to look out for you. I'm going to dismiss some of the stuff and send you, get you up out of here real fast. Wow.
When I got there, the only thing he really had of his own that he came at me with, because the court clerks were like whispering to him and kind of like trying to get him going, tell him what to do or what he should do. But the only thing he asked me on his own that I seen came out of his own head was 2 times. He asked me, Mr. Christopher, are you trying to make some type of sovereign argument? And I heard you say it. I heard you say the courts recognize sovereign citizens as terrorists. So I stated to him, no, Your Honor, I'm just trying to understand the claim that's against me. I'm trying to, have the jurisdiction established. That was my exact answer. But, he would put his head down and shake, as he got the read of my motion. I think he was thinking that he was just going to try to overrule it. But as he seen what was in it, he passed it to the clerk. And he asked me again, so it's not a sovereign argument at the beginning. I'm like, no, sir, I'm just trying to get the evidence that supports the claim. And, he tried to force me into putting in my plea, which when it started, there was no prosecutor, no police, nobody there to represent the plaintiff. So as I said, I have questions for the plaintiff and whatnot. He's like, well, it doesn't go like that. They're not here. So I said, well, if you're going to force me to proceed, then I have some motions that I would like to file. So I filled out, the case number and all that. I handed them my motions. And I also, I said, if you're going to proceed under the assumption that the plaintiff has jurisdiction and you're going to force me to put in a plea, I have my plea here that I would like to put in. I have the unsigned plea that I got from your documents. I gave him that.
Okay.
Like I said, he looked over the motions. He passed those to the court clerks. He gave me the plea back. He gave it back to the bailiff and gave it back to me. And I said,
Well, this is the plea of guilty, right? But James? This is the plea of guilty, right? All right, we're near the end of the show, so unfortunately we lost James. For anyone that we were not able to get to on the show today, we are live on the Wednesday broadcast, of course, from 4 to 5 Mountain Standard Time. And so, yeah, whoever we miss, we can get on that day. What I would say here, that the unsigned plea of guilty is pretty straightforward, and we're gathering evidence that the judge is so biased in favor of the prosecution. If they plead not guilty, that they're so biased in favor of the prosecution that they're willing to lie and to cover up for them. Contact me definitely on the Wednesday show. Hopefully we have a better connection and you don't have to wait almost 3 hours to get on. I don't know why we couldn't get them before. I do want to address something real quick here since we're at the end of the show and people are going to be tuning out soon anyway. Broken spoke here on the chat. I get it, man. I did on a live broadcast going vegan. It's a matter of being ethically consistent. If you know you can't win the argument, and you cannot win, there is no rational argument against veganism. I mean, it is wrong to cause unnecessary harm and death. It is drastic. I mean, the effects on our health are drastic. We are not omnivores. Omnivores, here's the key. Omnivores do not get heart disease. They do not get atherosclerosis. Carnivores and omnivores don't get such heart disease from having saturated fat and cholesterol. And cholesterol only comes from eating animals. So that's a big clue right there. There's the intestine length and just for which is a big one. Even if you want to be, look at it just for yourself, it is so unhealthy to eat animal products. But to act more ethically consistent, we can start doing, and today, we're anarchists because we are acting as more consistent with our basic ethical and moral principles of do no harm, live honestly, injure no one, give every man his due, and trying to be consistent with those principles. None of us are 100% consistent, but there are certain parts of our lives where we can be more consistent, and we can start today. Be more ethically consistent. Do no harm. If you're not okay with walking up and punching a cow in the face, or kicking a cat, or taking a stick and just hitting a pig or something, it's because it's wrong to cause unnecessary harm. And so It's also unnecessary, you know, to eat animals, to kill them. We don't need to do that. Even if we were omnivores, we can make ethical choices. That's the difference between us. We are ethical, moral actors. We don't have to do that. There's nothing that we get from animals that we, nutrition-wise, that we can't get from plants, and to be strong and healthy. So just act more morally consistent. Easy to do in this arena. We'll be back. Until next time here on the No State Project. Salud.